Alrighty, hello. Welcome to the KLP Talk Child Support presentation today. I'm Kate Pateman. I'm the Director and Founder here at KLP Family Law, and I'll be the host for the webinar today. Just for some technical stuff, can you please, you should have a little button that says raise your hand or something like that. If you could do that, if you can hear me, just so that I know that. Excellent, we've got all hands raising right now. That's perfect. Okay, so the technology is working and hopefully you'll be able to see my screen. If that's the case, can you also just raise your hand to make sure that you can see the screen? Perfect, excellent. Technology works. That's excellent. Okay, so we've got a fair bit of content to get through today. So what I wanted to do is talk to you just quickly about the limitations of today. So today I can't give any legal advice, but what I can do is give you a lot of legal information. And the reason why I can't give specific legal advice or any legal advice is because every matter is quite different. There's no one size fits all when it comes to family law, particularly child support. But the information you obtain today is just the start. This webinar is designed for the mamas and papas out there. So I'm hoping that I've been able to condense what is a very complex area of law into something that you'll be able to understand. And that's got nothing to do with the fact that you guys haven't gone through law school, because even some solicitors find this area quite complex. So if there's anything that you're not too sure about or you think that's not explained too well, your feedback is invaluable to me. So please email me. I'll give you all my contact details at the end. And after today's webinar, you will get some emails just to give you some further information. Reply to those. If there's any feedback you can give me, the good, the bad, and the ugly, anything helps. So what we'll be covering today. So what we'll be covering is the practicalities. What is child support, who's entitled to it or who's liable for it, how it's calculated, what expenses can be included, how to change an assessment and the process to object, review or appeal a decision, and then just quickly we'll touch upon how to document a private agreement. We'll go through what that actually means a little bit further. So straight into it, the practicalities. First up, just it can be and will be frustrating and very confusing. It is a government organisation that deals with child support, so they have a lot of processes and admin, and a lot of the times that can get very confusing. So if you're finding yourself a bit confused or frustrated, don't feel that you're alone. A lot of parents feel very frustrated and very confused when it comes to child support. So the best slide, and just remember you will all get an email copy of these slides at the end of the webinar. So all this information will be in it. But what I've given you here is where to find some information. It's no longer actually called the Child Support Agency. It's called the Department of Human Services Child Support, their Child Support Division. So I'm going to refer to it as DHS throughout this webinar. Here, some excellent information. The online guide, that is fantastic. It sort of takes you through each step of the act and the sections and what needs to happen. And I don't have it up right now. That's the child support calculator, which is one of those where to find information. So I'll just drag that off, but I'll just get the DHS website in for you. Because I just want to show you the tabs. It really is an easy website to navigate around. The other one, there's a parent's guide. So for solicitors, they've actually got a guide and a hotline as well, but for parents, they've specifically got a guide for you guys as well. The online calculator, like I say, that's fantastic, and I'll actually take you through that in this webinar. And there's also an app. I've never used it, and I haven't had any feedback about it, but I did find it when getting the information to make this presentation. So the link's there, give it a go. Let me know any feedback if you think it's great or not. That'll be great. So just some top tips to start us off. You can actually apply for child support, and in fact, if you're on Centrelink payments, you must apply for child support unless you can get an exemption. But once you apply, it might be advisable initially not to collect straight away, only because if you haven't spoken to the other parent, or if it's really quite a recent separation, I have found that once they're advised that there's an assessment in place and then the DHS try and collect, that's when emotions start to flare, and they're not the good emotions. So it can prevent some agreements coming into play in relation to even the care arrangements for the kids, property settlement, all the other stuff when it comes to separation. So by all means, get the other parent assessed, but perhaps ask DHS not to collect straight away. If you don't collect straight away, just be mindful that you can actually get DHS to collect at a later date, and they can actually backdate the collections by about 3 months without any court order or anything like that. But the best tip is just to call DHS or check out online on the calculator what the amount might be, just so that you're aware, but also so that you can use it in negotiations or discussions if you're having to deal with property settlement or the care arrangements for kids. So that's my top tips. So then we get straight into what is it and who's entitled to it. So the what is it, the government says that the aim is to ensure that children receive an adequate level of financial support from both parents following a separation, and to assess how much a parent should financially contribute to the support of a child. We actually use a formula, which I'll go through. A lot of people don't agree with that aim and feel that child support payments are not being used in the right manner, but all that I have to say to that is if the child's in good health, clothes, properly housed and is being fed, you can kind of be assured that the child support payments are in some way getting to the child. Next, how do you know if you're entitled to it? So if you're a parent or a carer, you're called the payee, and you may be entitled to child support if the children are under 18. So once they are over 18, and some other factors, for example, if they are 17 but they finalise high school, they may be cut off for child support, but you may be able to make an application with the Child Support Agency to extend it until the child finalises their high school. I did say they were 17, if they were 18 in their final year. If the children live with you or spend time with you, if your income is higher or lower than the other parent, you still may be entitled to it. It just depends on the percentage of care and some other factors, which we'll go through when we're talking about the formula. And you know if you're liable for it if you're a parent, you're called the payer, and that could be a biological parent or even a step-parent. Usually with step-parents, there may need to be an order for you to pay child support. It may not go through the Child Support Agency, but certainly you may be liable. If the children are under 18 again, if the children do spend time with you, or even if they don't spend time with you, you may be liable to pay child support. Your income will generally be higher than the payees, however, it's not always the case because, again, it depends on the percentage of care and some other factors. How do you get child support payments? Well, the assessment is through DHS, which I was saying before used to be called the Child Support Agency. We'll go through that process of how to get the assessment, how the assessment's done. You could also get it through what's called a private agreement, and I'll touch upon that today towards the end of the webinar. So that's where you're not actually going through the Child Support Agency and getting the assessment and whatnot, but you've come to an agreement as to what sort of child support will be paid. And that may be not just periodic payments, i.e. weekly payments. It could be that you're paying for other things, such as school fees or private health and those sort of things. And the third way of getting it is through a court order. And I'm not going to go through that today simply because I'm time restricted. But that is a bit of a process, and you do need to go through the review processes through DHS before you will be able to go straight to court and get an order. So the big question, how's it calculated? Now we call that the assessment. So the assessment is based on a formula, and you'll see there in the heading I've got ... S, so there's formulas. There's one basic formula, however there's actually 6 all up different formulas that can be used. But each of those formulas are a variation of the basic formula, and the basic formula is what I'm going to go through today, which is for a single child support case, i.e. 2 parents and 1 child or 2 child, 3 child or children that are biologically or children of those 2 parents. The other formulas are such things as if there's a carer involved, there may be, well, there are 5 others. I won't go through those today, but I will be able to provide a link to the website, which will go through each of those other 5 formulas, but we'll certainly be going through the basic formula today. Now, if you've applied for an assessment, you would more than likely have received a letter from DHS. It's a confusing letter. Sometimes, for whatever reason, they may send 3 letters that are slightly different. And the difference is usually here. If you just have a look here, the assessment period, that may be different. So this is a redacted real-life assessment that someone has received. And you'll see here that it's got the daily, weekly, fortnightly, monthly rates, but it also talks about steps. It's got steps 1 to 3, which is about income, steps 4 and 5, which is about care and cost percentage, and then it's got here step 6, child support percentage, step 7, costs of the children, and step 8, the child support amount payable. What does that all actually mean? Well, that is actually, if I can click forward, the basic formula, okay? There's 8 steps involved. So you'll see that the assessment is not a simple thing. There are 8 steps, and these 8 steps are important to know and understand simply because if, say, the parent's percentage or level of care has been assessed as being a certain amount, but you say that's incorrect, well, then that's a basis for you to either object or seek a change of the assessment. And we'll go through that later. But you need to understand each of these different steps to know what you can actually try and object to or try and change. So your first step is the most obvious. It's working out, especially when we're talking about money, what is each parent's child support income? Child support income, it basically means what's your adjusted taxable income. So that includes tax-free benefits and pensions, your taxable income, everything that you actually get. So if you're on a government pension, that is actually part of child support income. Okay, in some other places, even though it's not taxed, some of those are not taxed, it still forms part of the child support income. Then the next step, and then the child support income will also factor in a self-support amount. So if your taxable income, say, is $90,000 a year, and your self-support income, and if we go back to that letter, you'll actually see in there, down here, well, this is steps 1 to 3, your less self-support income, and it's the same for you both. So that's in 2016 was $23,752,000. This year in 2017 is $24,154. It'll go up slightly each year with CPI. Okay. And here in the letter, you'll see that the child support income will be your adjusted taxable income minus your self-support amount. And that's what is required for step 1. Step 2 is easy. Work out the parents' combined child support income. So you just add the 2 figures, essentially, that you got with the child support income. So looking on here, parent A is 126 odd thousand, parent B is 60 odd thousand. So combining that is the same for each because it's just the 126 plus the 60, 186. And then the next step that we need to go through is to work out each parent's percentage or level of care. Now with this, there's actually a table which will show you if you have here on this right-hand corner number of nights in care. So if you only see your children 1 night a week, that'll be, will actually be 52. So you'll be regular. So you'll be 14% to less than 35%. So you'll be in that bracket. And conversely, if you're a primary carer, you need to have the children for at least 238 nights in care, to most 313. So that's where, well, I hear a lot of people saying, instead of, I would like to spend, Thursdays to Fridays with Johnny or whatever, I hear I need 52 nights in care. And that's where this comes from, okay, because it drops up into that percentage of care. Now, if we go back to that previous slide, excuse me, which is not going to, previous, there we go. So that's the percentage or level of care, and then we need to work out the cost of percentage, which is another table. And you'll get all these tables, but it's just good for you guys to know what it is so that you can see the letter. And if you say, oops, if you think, no, I have more than that, you can actually object to the assessment and seek that it be changed. So here you'll see, excuse me, if your percentage of care was 14 to less than 35%, then your cost percentage is 24%. I may have lost some of you at the moment because this is very dry and boring, but it is something that you do need to know simply because the assessment is based on this formula. Okay, so that's working out each parent's cost percentage. So you get it from that table. And then next, you actually need to work out the child support percentage. So in order to do that, you simply subtract the parent's cost percentage from the income percentage. I don't actually have an example to throw up there, which would have been good, and I might do that in future. And then step 7, work out the cost of the child, which again is in another table. Cost of the child, okay? This cost of the child is in relation to their ages. So if the children are aged 0 to 12 years and you've got one child, the percentage of care is here, and it's in relation to the parents' combined child support incomes. It can get a bit confusing, and it is something that each matter is individually different. You need to sit down and look at the letter, but also take into account what it actually means. And then number 8, if a parent has a positive child support percentage under step 6, the annual rate of child support payable by the parent for the child for the day is worked out using the formula, the child support percentage times the cost of the child. And that's how you actually get the amount that you need to pay in that letter. It is confusing. It is a lot of steps involved, but hopefully the tables that I've included in here will be able to take you through that letter, but also show you how each of those steps are assessed. The easier way to do it, if you haven't yet been assessed, is to use the online calculator. It is a great tool and that's the one that I threw up earlier, and I'll just bring it back in to play. Here it is here. This will actually, it's very easy to use, and you'll be able to easily put in the answers simply because it's your name, how many children. You just put in your first name. In fact, even if you put nothing in there, it's okay. Are there any other children and whatnot? And then it just goes on to the next. I have to put in stuff. Go on to the next. And this is where it'll ask for your income. So yours and the other parents, and whether you're receiving any income support payments. And then the next screen will just be in relation to the children. It'll ask for the names, well, first name, not the last, the date of birth, and also how many nights in care. They actually do it weekly, fortnightly, and yearly. And then you go to the next page, it will actually spit out an assessment. Now, that assessment won't be 100% the same as what DHS may assess it as being, but I have found that it's around about, $20 or $30 either side, but it's a good indication as to what it may be. So it does give you a good idea when you're negotiating, or if you're thinking, should I, how much is it worth, especially if you are the payer. So that's the formula and the assessment. My best advice is to call DHS or using the online calculator, but once you get the letter, and if you think, holy, that's really quite high, why is it so high? Go through those 8 steps that we've just gone through, and using the tables, see whether they've used the incorrect percentage of care or anything like that, because if they have, you'll need to notify them and ask for it to be changed to show what it really should be. Next part of the webinar will be what can be included, okay, in the actual assessment. So you've got an assessment, say it's $300 per week, but if you're making other payments, for example, amounts directly to the other parent or to a third party, then you can actually use those to offset your assessment. They call it non-agency payments, or NAPs. Everyone loves acronyms. It will offset child support debts between parents. So, for example, if for some reason you've got, $3,000 lump sum that you're able to pay, you'll be able to offset that on any future assessment or debt that you may have with child support. And again, crediting lump sum payments. The non-agency payments, or the NAPs, they're the ones that I see a lot. So they're payments made to the payee, so the other parent, or payments made to third parties, or even non-cash transfers to the payee. So what are NAPs and prescribed payment, NAPs and prescribed payments? They are 2 different things. So the non-agency payment and the prescribed payment are different in the sense that to credit 100% of a non-agency payment, so for example, if you've made a payment and it was agreed that it would be for or in lieu of child support, for example, you paid the other parent $200, you can actually get that applied to the assessment and it will be reduced by that amount. If it's a prescribed payment, and I'll go on the next slide to give some examples of what they are, regardless of the intention, so if there's an agreement or not that it should be for child support, the child support agency can credit up to 30% of the assessment only if the payee has less than 14% care. So if you've got shared care going on, you won't be able to credit the prescribed payment against the assessment. And non-agency payments can be credited towards future payments. So the examples of some prescribed payments, so for example, if you guys, the 2 parents can't agree that it was for child support, the registrar of the DHS will be able to apply it towards or credit it towards your assessment. Childcare costs, less any refund, school fees and levies, prescribed uniforms and books, essential medical and dental services, and these are only if they are essential in the opinion of a practitioner approved by a private health fund. Payee's share of the costs of a home, so if you've still got a jointly owned home and you're paying the full mortgage, the registrar will be able to credit or offset that with your child support payments or the assessment, and the cost of the payee's car, so the parent that's receiving the payments, if you're paying for costs of the car. Offsetting child support debts, which is the second NAP or non-agency payment, where there's two parents which have debts to each other, it's actually a debt to the Commonwealth. And because of an assessment or a liability to pay under a court order, so they're the two debts that you can have, and they'll be offset. So, for example, if the father has a debt to the mother of $3,000, but the mother has a debt to the father of $4,000, well, then it will be offset with each other, and the mother will just have a debt to the father of $1,000 once it's offset, and the father will have no debt. If that makes sense, hopefully it does. The offsetting cannot be for spousal maintenance or an overseas maintenance order, and the payer with the larger debt is required to pay the net amount. So that's what I was saying before. The mother would still be, in that example, liable to pay the $1,000 that's still owing after the offsetting. And crediting lump sum payments. So you can get a credit for a lump sum payment that has been made in a binding child support agreement or a court order if the amount equals or exceeds the annual rate of child support, of the child support assessment. It's credited at the end of the financial year. It's usually 100% credited until otherwise stated. So they're the three non-agency payments that you can ask the child support to take into, DHS, to take it into account with the assessment. Now, the next part of this webinar is the changing of an assessment and objecting or reviewing or appealing a decision. So this is what I was saying throughout. If there's something that you're not agreeable to in the actual assessment, or you think that they've got wrong, this is the part that will be relevant to you to consider. Now, there is a difference between an assessment and a decision. So an assessment is based on the formula, so that's what we've just gone through, and is what DHS says you are entitled to or liable to pay. A decision, however, is where DHS makes an assessment or a change to the assessment based on certain information. So, for example, if you've objected to the assessment and said, no, that's wrong, it should actually be X, Y, Z, the DHS will then make a decision on that objection. And it may be to allow it or not to allow it, but those are the difference. The assessment is what is first off made, and the decision is where DHS has assessed, made a further assessment, or taken into account an objection or tried to change the assessment from an application from either of the parents. So if you're wanting to change an assessment, not the decision that DHS may have made, but an assessment based on the formula, this is what you need to remember. You need to have an assessment in place, obviously. You usually cannot change an assessment for more than 18 months after making the application. If you want to do it for longer than that, you may need to go to court to get a court order to allow that to happen. That's just a restriction in the Child Support Act. It is where you consider DHS should take into account a special circumstance in relation to the assessment, and you must still make the payments unless you get a stay order from the court. That's a very important one. You still do need to make payments. A lot of people think, well, I'm asking for a change or I'm objecting to a decision, so therefore I don't need to pay anything. You do. And the registrar must be satisfied that this is the registrar of DHS, must be satisfied that it's just and equitable to make the change or otherwise proper. Just and equitable is just a fancy word that lawyers and agencies use to basically say it needs to be legally fair. So some reasons for change. There are 9 or 10 reasons which I'll go through. The cost of maintaining a child is significantly affected by high costs of enabling a parent to spend time with or communicate with the child. The costs of maintaining a child are significantly affected by the high costs associated with the child's special needs. The costs are significantly affected for educational training. So that, for example, it could be private school fees if they're not taken into account under the prescribed payments. The child support assessment is unfair because the child's income, earning capacity, property or financial resources. So that's probably more so for older children when they are in the workforce but still going to school and therefore are still covered by the assessment. The child support assessment is unfair because the payer has paid or transferred money, goods or property to the child, the payee, or a third party for the benefit of the child. The costs of maintaining a child are significantly affected by the high child care costs for the child, and the child is under the age of 12. The parents' necessary expenses significantly affect their capacity to support the child. The child support assessment is unfair because of the income, earning capacity, property or financial resources of one or both parents. That one, that reason 8, that one is used a lot because sometimes parents will run their income through a company or other such entity, and it may not be what their capacity to earn is, and so it does make the assessment unfair because their taxable income is a lot less. We have found that in a couple of matters. The next one, number 9, is the parent's capacity to support the child is significantly affected by their duty to maintain another child or person, the necessary expenses in supporting that other child or person, and the high cost of enabling them to spend time with or communicate with another child or person they have a duty to maintain. And the last one is the parent's responsibility to maintain a resident child significantly reduces their capacity to support the child support child. So each of those 10 reasons, if one of them or a couple of them apply to you, then you can make an application to change the assessment. You will need to have your evidence, obviously, to back up what you're saying, but those are the 10. Now, the process, once you've ascertained, yes, listen, number 8 or number 9 or whichever one applies to me, then you need to actually seek the change. So this is the process that you'll go through. So first off, you need to get the assessment. Then what will happen is you'll need to make the application to change the assessment. Now that is a form that is obtained from the DHS website. It's a prescribed form, you'll complete that. Then the other parent will have a right to respond, and then you'll both have an opportunity to be heard. So be contacted by telephone. You can't usually have a representative, whether that's a solicitor or a support person, appear on your behalf. And the registrar is not obligated to conduct an investigation. So what that means is you really need to have all of what we call your evidence or your documents to support the application to change attached to the application. Now, once you've had the opportunity to be heard, what will then happen is you can actually reach an agreement between each other as to what should happen. That does need to be approved by the registrar, and they usually are, unless it's not just and equitable, which is that other component that the registrar must be satisfied of. If you can't reach an agreement, then a decision will be made, and you will get some reasons for that decision. So what to include if you are wanting to change an assessment? There's no, again, a one-size-fits-all. It does depend on which reason. So you've got all those 10, and I can't really go through all of those reasons and the specific details you might need, because even within those individual reasons, there may be a lot of different circumstances that are at play. But the application and the online guide does set out some details of what to include or what the registrar looks for. So those links that I gave you at the beginning of this webinar, have a look through those, because it does actually show you not everything, but some things to get you started and on the way. Now, you would have seen in that previous slide about the process, at the end you've got a decision. So remember, I was talking the difference between an assessment and decision. So now that you have a decision that's been made about the change of assessment, you can either object or appeal that decision. So again, you need to have that assessment in place, and you need to have a decision that's been made. And it's where you consider that DHS has made a mistake again, or did not, or did include a circumstance, and you must still make the payment, okay? Again, throughout all this, you must still make the payment. At the end of the day, if you're found to have lesser payments that needed to be made and it's backdated, then you will get a credit, okay? So there are still ways around getting those monies back, so don't worry about that. So the grounds for review or objection are one, that the percentage of care of the children in the assessment was wrong, the income used in the assessment was wrong, or the estimate of income was wrong. A non-agency payment should have or should not have been taken into account. The acceptance of an application for child support. So that's one thing that we haven't actually gone through today because of time, but if you don't think that someone is entitled to make an application for child support, this is where you can object to the assessment. If there's been a refusal of an application to get child support, again, you can object or ask for a review of that. If there's been a suspension of child support payments due to an administration review, or if there's a change of assessment in special circumstances decision that's been made. So that's what we were just talking about before. And there is a number 9 ground, which is other, basically any other reason that's relevant. So this is the process if you're wanting to object to or seek a review of a decision. So again, you need to have the assessment, and then within 28 days of the assessment, or 90 days if you're overseas, you need to lodge an objection or seek a review. And again, excuse me, within 60 days of that occurring, or 120 days if you're overseas, the registrar will hand down a decision. Now, within 28 days of that decision, or 90 days if you're overseas, if you're not happy with it for one of those grounds, you can appeal to the Administrative Appeals Tribunal. It used to be the SSAT or something like that. Usually with most new governments, we have new tribunals, but that's the latest one, the AAT. And then this is the process to appealing the AT. Now, you would have already realised that it's a bit of a process. So way back when we were talking about the formula, and I'm sure that you've blocked that out of your mind because it was a bit of a hefty thing, but you'll see that there is a bit of a process for each step of the way. So this part, if you're wanting to appeal, so you've either sought a change of an assessment or you're objecting to a decision, if you're wanting to then appeal all that, you've got to go to the AAT. So my slides have got a little bit weird, but you need to lodge the appeal to the AAT within 28 days of the decision being made. Then you'll have a directions hearing where you may be asked to provide more material or details. Then you'll have a hearing, and it's quasi-informal from what my experience has been. Then from that hearing, there'll be some reasons for the decision. And then this part here, once you've got the reasons for the decision or the determination, which is usually issued 14 days after the hearing, you can either then appeal to the Federal Circuit Court, the FCC, or you can seek a second review, and if you're still not happy with that, you can then appeal to the FCC. Now, you can only appeal to the FCC, the Federal Circuit Court, which is part of the family law courts, if it's an error of law. You can't just appeal simply because you're still unhappy. So that's the flow chart of appealing to the AAT. And the AAT is separate to DHS. It is a totally separate tribunal, and you're not dealing with the registrar of DHS. They won't be making the decision. It's actually the tribunal members, okay? And it is a separate application that you need to make. So what to include in that application? You need to include the date of the decision letter that you received from DHS, the date when you actually received the letter, because it may be different to the date on the letter. You need to include details about the decision you're wanting to object to, why you think it's wrong, and if you can, you need evidence or documents to back up your objection. What documents? Again, it all depends on what the reason is that you're objecting to. Now, make sure that you use the correct forms if you're going to do any of these appeals or requests to change an assessment. And here are the 3 main forms. So the change of an assessment, there's the link there. To object or review a decision, there's the form there. And then to appeal to the AAT, it's not part of the DHS website. It's a separate website because it is a separate entity, and that is with the AAT website, but the details are there. So a fair bit that you may need to do But if you don't use solicitors, and most people don't, simply because the forms are there and it's a free process to do, and some of them don't even allow a representative to be involved, it's free. All that it's going to really do is take up your time. So you really need to toss up how much is your time worth vis-a-vis how much you think the decision or the assessment is wrong. Now, the last part, so we're at the pointy end of the webinar, so we might hopefully have time for some questions. How to document a private agreement. So now that I've gone through the assessment, the formula, how to change, object, and appeal the assessment or a decision, you can get away from that whole scene by coming to a private agreement. So that's where you sit down with the other parent and you come to an agreement and you document it in a way that's private. How do we do that? Well, there's two ways. You've got a binding child support agreement and you've got a limited child support agreement. Okay, so we'll start with the binding child support agreement. So this is the one where you do need a solicitor to sign a certificate to make it binding, and the reason for that is because it's binding. It's binding you both until the child or children are 18 years of age. It is, in some circumstances, and depending on what terminating events you have listed in your agreement, it is difficult to get out of. So if your income, if you've come to an agreement, your income goes up substantially, then the other parent won't be able to go, oh, I don't like this, I'm going to go to the child support agency. They'll have to make an application to try and set aside the binding child support agreement. If it's done right, that may not happen. Now, there is a form and the lawyer's certificate online. However, lawyers being lawyers, a lot of them like to do up their own forms. And I do see some benefit in that depending on what the agreement is, simply because the forms on the child support website, DHS website, are not as detailed as what a lawyer would draft up. So when it comes to those terminating events or other things particular to your family, those forms don't actually include it. It will apply until the child turns 18 or the agreement's terminated, as I've said. You can actually have the agreements that are less than the assessment. So if you're assessed to pay $300 per week, this binding child support agreement can say that you pay $100 per week or nothing. So it can be very unfair. It can also include a range of payments, such as school fees, private health insurance, extracurricular payments, those sort of things. It can be periodic payments, can be lump sum, can include an assessment amount as well as those other things. So the world really is your oyster. So it does open up a lot of flexibility for both parents to come to an agreement that suits that family. Because as you've seen, the assessment is really one size can fit all, so they say. The next one is a limited child support agreement. Now this one, you don't need a solicitor to sign a certificate, but the agreement must be the same or more than the assessment. It can't be less. And the agreement can end quite easily or more easier than a binding child support agreement. It can end if the agreement in writing, you make a new one or enter into a binding agreement, or it has been 3 years and a parent asks DHS to end it. So the limited ones are limited to a maximum of 3 years, provided the other parent or a parent asks to end it. And it can be terminated if the assessment varies by more than 15% and the parent asks DHS to end it. So if you've got a limited child support agreement and neither of the parents asks to end it, it will just continue on. So just be wary of that as well. If you've got one already, or if you're going to enter into it and you're wanting it to end after that 3 years, you actually have to advise the child support agency or DHS that it's ended, because those ones usually do register with DHS, which I'll get to in a moment. But the forms are online. The binding and limited child support agreement is actually the same form, and hence why I say that some lawyers would prefer to do up a proper binding child support agreement that fits your family specifically. But they are, there is a form online. There is also the form to register an agreement with DHS. So if you do have a binding or a limited child support agreement, you can actually get DHS to collect on your behalf. And the lawyer's certificate is also online, and there are all the links there. And that comes to that question of, do I have to register at the binding or the limited agreement with DHS? It's only if you want them to collect on your behalf. There's no real reason. And I used to, of abundance of caution, register all agreements, whether binding or limited, with the CSA back then, but the DHS. Recently, we went to do one, and they've sort of said, you don't have to do it. It's only if you want us to collect. So it's really up to you what you want to do. If you don't want them to collect, then you can just have the form. But if it becomes difficult and you do want them to collect, you can't just make an assessment because you have those agreements in place. You need to register that. So that brings us to the pointy ends. Where to from here? You're inundated, I'm sure, with a lot of information. You're probably wanting to digest a lot of it, and you will get the slides later on tonight, I think it is, or later on in the week. So have a look through them, refresh, but just remember the 5 Ps, or as a colleague of mine refers to it, the 6 Ps. Proper preparation prevents piss poor performance. And that's very true. So understand things. If you've just separated, or if you don't have a child support assessment in place, go and have a look at the online calculator. Think about things. Talk to the other parent, mediation or something like that, just so that they're not confronted with it without knowing anything. Have a look at the online guide, which I've given you the link to. Go to mediation if you can't agree, or even just try to talk or negotiate. If it is all a little bit too much, do see a solicitor just to get advice specific to your matter. It doesn't have to go anywhere. Just because you see a solicitor doesn't mean you need to retain them. It might be that you just see them on a one-off and go, okay, all my answers specifically that you've got have been answered, and you don't need anything else from the solicitor, and you can go off and do what you need to do. And the last thing is, speak with your former partner, the other parent. You're going to have to. It's preferable if you can, but obviously if there is safety fears, it's out of the question. But child support is a very heated not discussion, but topic, I normally find, especially if someone just springs it on the other parent and they're really not expecting it, because you've got to realise, even if you've separated, there's obviously financial changes, and then all of a sudden you get assessed for child support. It's another financial change. Finances can be a bit tricky. So that's essentially it in a nutshell, a very small nutshell. As you can see, it's a very complex area, and there's a lot more that we could have gone through. But if anyone's got any questions, flick them through. But otherwise, hopefully that gives you a little bit of information. But again, your feedback. I would love to get some feedback about what you thought about the webinar, but in particular, what questions specifically that you may have had that I didn't touch upon, just simply so I can then factor that into future webinars, but I'll also answer your question, provided it's not legal advice that you're after, but I'll be able to answer the question with the information via email if you do shoot it through to me. So that's the webinar for today. Because I talk fast, I've pulled it up a bit earlier than expected, which is always good. It gets you guys back into your daily routine a lot earlier. So I thank you all for attending the webinar. And again, I invite that feedback. But otherwise, have a good day and a great rest of the week. Thank you.